How long does a criminal case last? If I file a criminal complaint, by when should I expect a conviction? Is there any timeline for a criminal case to get over? What would a life cycle of a criminal case look like? To get answers to all these things and all these queries, watch series of these videos right till the end. Ladies and gentlemen, boys and girls, hello, namaskar, and welcome to Law Charcha. Is criminal procedure as simple as the encounters of the rape and murder convicts, sorry, murder accused, as done recently in Hyderabad? Certainly not. Is criminal procedure as lengthy as the one followed in the Nirbhaya case? Certainly yes. There are stages in a criminal case which are regulated as per the Criminal Procedure Code. This is to ensure a proper trial because every man is innocent until proven guilty. Today, who knows that a person encountered may not be the actual guilty and just a scapegoat of power politics? Just imagine if that is the case. Hence, a proper trial is necessary to ensure justice and plug all the doubts before convicting a person. At least there is a satisfaction, as in the case of Nirbhaya, that the person hanged were beyond doubt the culprits. Let's see how a criminal case life cycle looks like and how the criminal procedure actually works and moves forward. Let's have a look.
There are four ways in which a criminal proceeding can be initiated. One is by registering an FIR under section 154. For more details about FIR and how it is registered, watch my video on FIR. If the police refuses to register FIR, then one can approach the magistrate under section 156(3) of the Code of Criminal Procedure, or it can approach High Court in its writ jurisdiction and seek directions under mandamus to police for registering the FIR. A private complaint can also be filed before a magistrate. Section 190 under the Code of Criminal Procedure is the relevant provision that enables magistrate to take cognizance. Then there are certain special enactments for certain offences. For instance, an offence under Negotiable Instruments Act is triable by the magistrate court. Then offence under SEBI is by a special court. For instance, in Mumbai, one of the sessions court is designated as special court for SEBI case. When a case proceeds on an FIR, first thing is the investigation, which consists of collecting evidence. This may require taking accused into custody depending upon the nature of the offence. The investigation is done by police. They may arrest accused depending on nature of offence. They could have to recover material with respect to crime, which could be weapons in case of bodily injuries. It could be check or other documents in a relevant case of forgery, cheating, or criminal breach of trust. Accused can also seek remedies like bail, anticipatory bail. I will recommend viewers to watch my videos on arrest, bail, anticipatory bail, and also video on charge sheet, which is our next stage. What is charge sheet is elaborated in my video. Then comes framing of charge, where the judge charges the accused of offences based on the material in the charge sheet. That is also when the accused is explicitly told about charges against him, when he may decide to plead guilty or plead not guilty. Upon him pleading not guilty, the trial in true sense begins, where the witnesses of the prosecution are examined and the accused gets opportunity to cross-examine the witnesses. Then this is what happens at the stage of examination of witnesses. Then a statement of accused is recorded in question answer form where accused is asked series of questions based on the evidence against him. This we refer to as recording of statement of accused under 313. At the end, he is also given opportunity to lead evidence where he can examine himself or other witnesses. It is optional, and please understand here that it is not compulsory for accused to examine himself. Do not go by novels or movies which wrongly pose such thing on many occasions. Remember, it is for the prosecution to prove the case against accused. It is not for the accused to prove that he has not committed the offense. So it is the onus is on the burden is on the prosecution. Then both the parties, that is prosecution and defense, are allowed to present their respective arguments, oral, written, or both. And finally, the judge pronounces his judgment. These are basic stages of a criminal case. If these were the only stages, the case would be over within couple of months. In next video, we will dissect these cases and see what all things can happen during a trial. That is, in between these stages, what all things can happen. In the meantime, stay fit, stay healthy, and subscribe for more videos and more Law Charcha. Thanks.